Good morning, everyone. Am I audible to you all? So please let me know if I'm audible. Yes. Okay. So good morning. Welcome to SSM Sharda Educations. Today we are discussing the continuation of polity current affairs of November month, which we have been discussing for the past 2 days. So what are all the topics we'll be seeing today is like we are going to discuss about formulas. So what are all the formulas that have been passed, and what are all the impacts of those formulas, what happened in the past 1 year, and then it has been repealed now, and why it has been repealed. All these kind of questions we'll be discussing today, and then we'll be seeing some topics which are important for the preliminary exam also. So first, parliamentary committees in India. Yesterday we saw one of the parliamentary committee called a joint parliamentary committee. So we know that joint parliamentary committee is an ad hoc committee. Okay. So ad hoc committee means that ad hoc committee is a temporary committee which is formed for a particular subject matter for a particular period of time. So usually it is usually it is formed by passing a motion in one of the house of parliament and the other house agrees to it. So that is what is joint parliamentary committee. So what is parliamentary committees in India? What is in general what is called as parliamentary committee in India is that a parliamentary committee has certain requirements. So what are those? It is appointed by the house or nominated by the speaker or chairman of that particular house. Speaker in Lok Sabha and chairman in Rajya Sabha. So it works under the direction of speaker. It should present its report to the house or to the speaker or chairman. Even yesterday in the joint parliamentary committee, we saw what it will be presenting a report to the government, which is only persuasive in nature, and it cannot force the government to accept the report. On the other side, the government will uh, um, make a fresh investigation on that, and they will submit a report. Based on that, action taken report will be submitted by the joint parliamentary committee. So same here, any committee, any parliamentary committee will support a report to the house, to speaker or chairman. All these reports are discussable in the parliament. So it should have a secretariat provided by the Lok Sabha or Rajya Sabha. So these are the requirements of parliamentary committee. It can be a standing or ad hoc committee. These are the general requirements of a parliamentary committee. So the Constitution of India mentions these committee at different places, but there is no specific provisions for them. Like how much, what is the composition, or what is the tenure, what are all the functions of this committee has not been mentioned, but it has been mentioned by the rules of two houses. So keep this in mind. What is the question they are asking in the examination? So the details regarding the parliamentary committee are mentioned in the constitution. If that is a statement, no, it is wrong. It is not mentioned in the constitution, but it has been mentioned in the rules of two houses. So there are two types based on the function: standing or permanent, ad hoc or temporary. Consultative committees, what are these? It is different from the parliamentary committee in the following ways. So here in this, they have members of both the houses of the parliament. Ministers of states in charge, that is ministers or minister of state in charge, can be chairman of the committee concerned. Fine. They act as a bridge between members of parliament and ministers on government policies and effective governance. Next, they are constituted by the Ministry of Parliament Affairs. See, when we saw about parliamentary committee, it is formed by the parliament, either of the house. Either it can be a speaker or chairman. But here, what happens? Who's forming? It is constituted by the Ministry of Parliamentary Affairs. The Ministry of Parliamentary Affairs only constitutes this committee, consultative committee. It takes responsibility of everything of that committee. Fine. So the membership of committee is voluntary and may vary. It may be from 30 and maximum it can be 30 and minimum of 10. Within this it can vary according to the need. They are constituted on commencement of new Lok Sabha and dissolved at the end term of Lok Sabha. So I'm like explaining in terms of difference between, you have parliamentary committees, consultative committees. In these parliamentary committees, here the name itself gives you it is formed by the parliament. It can be either of the house speaker or chairman, but consultative committee is formed by Ministry of Parliamentary Affairs. Here it is giving report to the parliament. Here the ministry is responsible for everything here. And this number of members, it varies according to the need. Here it is maximum of 30 and minimum of 10. Here tenure is decided by the house or who's forming it. Here it is constituted at the commencement of new Lok Sabha and ended at the end term the end of the term of Lok Sabha. Next, Prevention of Children from Sexual Offences Act 2012. So what is this? It was enacted in 2012 and amended in 2019. That is why it is very important. This can be a question. It was formulated to address sexual abuse and sexual exploitation of children and child pornography. Fine. So these are the three important things that has been explained, that has been addressed in this act. So this defines child as a person. This is very, very important. Okay. So which age is defined as children is anyone below 18 is defined as child according to this law. So the act also defines different forms of sexual abuses. So it provides for relief and rehabilitation as soon as the complaint is made. So who will take care of this is special juvenile police unit or local police will take care of this. So the maximum punishment according to this law is life imprisonment or death penalty. It is also providing minimum punishment of 3 years. So the maximum is life imprisonment or death penalty and minimum is 3 years. Fine. So very important. So it is also establishing special courts for the trial of offences under the Act, and this is general, neutral, and child-friendly act. Child-friendly act. Fine. So general, neutral. It is not, it's not like only a man who has been convicted under this law will face maximum penalty. When a woman is convicted, no. Whoever it is general, neutral, man, women, or third gender, anything it can be. This law is general, neutral, and it is child friendly. Okay, so that is very important. So section 8 of this act prescribes the punishment for offense of sexual assault, and section 7 mentions whoever with sexual intent touches the private part of the children or commit any such act which involves physical contact is said to have committed sexual assault. So this is what is very important, because here whoever, these are the keywords, whoever with sexual intent is touching a child is considered as someone who has committed sexual assault. Okay, so I'm repeating about this act. It was enacted in 2012 and amended in 2019. So this act is defining what is who is a child. Anyone below age of 18 is defined as a child, and this is also giving definitions for different form of sexual abuses. So here, who will take care of the issue? Special juvenile police force or local police will take care of these complaints, and minimum punishment of 3 years and maximum punishment of lifetime imprisonment or death penalty. Fine. So another definition is according to section 7 of POCSO Act mentions whoever with sexual intent touches a private part of a child is considered as someone who has committed sexual assault. So it is considered as victim-oriented statute, that is the damage caused to the victim assumes more importance. Okay, so here what is the damage caused to the victim is having more importance, and the convicted person has to prove that he is innocent. So India is a signatory to UN Convention on Rights of Child. So this act is a mandatory international commitment to protect the rights of children. The Goa Children's Act of 2003 was the only legislation before this which was focusing on child abuse, which was passed in 2003. Later, this after that in 2012, this was one which focused especially on child sexual abuse. Next is ordinance promulgation in India. Article 123, these kind of articles are very important. So yesterday when we were discussing in the class, I told you it is not required to memorize all the articles, but when there is a current affair and there is an article mentioned which is a very important topic, you have to remember the article. Even though they are not asking in preliminary examination sometime, this will help you in writing an introduction in the mains examination. Fine. So Article 123 deals with the ordinance making power of the president. He can only promulgate the ordinance when both the houses are either of the house is not in session. This is very important. This is a condition. So president cannot make a ordinance just like that. Either two houses should not be in a session or either of one house is not in the session. And this the president thinks it is necessary to act without, if there is something very urgent that has to be addressed, then president need not wait for both the houses or either of the houses to pass an act. So instead, what president can do is he can promulgate an ordinance, and later the houses has to give their they have to pass the ordinance. So an ordinance can be retrospective in nature. Retrospective is going back to the date. So when an ordinance is passed, so I told you the condition both the houses should not be in session or either of the house should not be in session. What happens if a president passes an ordinance when both the houses are in session? It will become void in nature. Okay. So in preliminary examination, they might ask you like, anything, any statement can be asked. Either of the house is in session, only one house is in session, all these things. What happens if it is past kind of question can be asked in that situation. If both the houses are in session and the president is passing an ordinance, it will become void in nature. The parliament has to approve the ordinance within 6 weeks from its reassembly. So this timing is very important, within 6 weeks. They might ask you like 6 weeks, 6 months kind of questions can be asked. So what happens, the 6 is very common in many topics. Is it weeks or months is very important. Fine. So 6 weeks is here. Because when you're studying emergency, you will come across this concept of 6 months often. So don't confuse with that. So when it is an ordinance, the president is passing an ordinance because both the houses or either of the houses not in session. So now the ordinance has been passed and it is being followed. But now both the houses are in session. So what happens? From the date of the session, from the date of commencement of the session, within 6 weeks of time, the parliament should approve that ordinance. So president promulgates an ordinance on the recommendation of union cabinet. This is also important. It's not on his own, on the recommendation of union cabinet. So what is the ordinance making power of governor? It is article 213. Just the numbers are shuffled. For president it is 123. For governor it is 213. That's all. Keep this in mind. President always comes first. Next the governor. So 123, 213. Keep this in mind. So governor initiates an ordinance only when a legislative assembly is not in session, when it's an unicameral legislature. In bicameral legislation, ordinance can be initiated when both the legislative assembly and council are not in the session. Fine. Now it is in the case of president, it is both the houses or either of the houses not in the session. But in case of governor, if it is a bicameral legislature, the governor can pass an ordinance when both the houses, legislative assembly and council are not in the session. Fine. Okay. Panchayat Extensions to Schedule Area Act 1996. So it is enacted by, this Panchayat extension to schedule area is also called as constitution within constitution. So this makes a very good introduction, idea. So you can write when there is a question related to Panchayat Extension to Schedule Area Act of 1996. It is also called as Constitution within Constitution. Is a law enacted by the Government of India to cover the scheduled area which are not covered in 73rd Constitutional Amendment Act. So this particular act extends the provision of Part 9 to the scheduled areas of the country. That is why it is called as Extension to Schedule, Panchayat Extension to Scheduled Act. So it brought powers further down to Gram Sabha level. It is now applicable in 5th schedule area, which deals with the administration of districts dominated by tribal communities and is in force in 10 states of the country. So what are those states? Jharkhand, Chhattisgarh, Odisha, Andhra Pradesh, Gujarat, Himachal Pradesh, Madhya Pradesh, Maharashtra, Rajasthan and Telangana, because these states have tribal population domination. Fine. So this PESA Act is applicable in these states, 10 states. So what is this? What is this act? What are the responsibility and function of Gram Sabha under this act? So they have the power to prohibit, regulate, restrict the sale and consumption of any intoxicant. Fine. So prohibit, regulate, restrict. So all these are keywords. The sale and consumption of any intoxicant. They also have the power to prevent alienation of land and try to restore any unlawfully alienated land of scheduled tribe. They have the power to manage village markets and they can exercise exercise their power control over money lending to scheduled tribes. Fine. Because money lending is a very big problem when it comes to scheduled tribes. Next, we know very well about president's power in terms of bills. Parliamentary bills. Okay, so generally we divide it as ordinary bill, money bill and amendment bill. Fine. So these are the things. So in ordinary bill, money bill and amendment bill, we know very well what happens. But now we are going to see in terms of state bills, the same ordinary money bill and amendment bill, what are all the president's veto power in that? We'll see that. So in terms of ordinary bill, the president can give assent. That this happens when governor reserves the bill to the president. Fine. So there is a state legislature. So there is a bill discussion and passage of bill is going on. So the governor has his own veto power. But now the governor is reserving the bill to the president. So what are all the powers of president is what we are discussing. So in ordinary bill, the president can give his assent, withhold, which is called as absolute veto, keep pending, pocket veto. We know pocket veto has no limit in terms of Indian president. Fine. So pocket veto, he can return it, which is called suspensive veto. So I'm writing it here. So there is a bill, state bill. So now it goes to the governor. The governor is reserving it to the president. So what are all the possibilities he has? He can give his assent. He can withhold it. Can withhold this. He can keep it pending, or he can return. So now as he returned, what will happen? So he is returning it and it is coming back to the president. Then he can give his assent, he can withhold or he can keep pending, he cannot return it again. Okay, next. In terms of money bill, he can give assent, withhold, keep it pending, he cannot return it. Constitutional amendment, we know very well the state legislature cannot introduce a bill which seeks amendment in the constitution. Only in parliament in either of the house. Okay, it is not like money bill. Money bill can only generate in Lok Sabha. Can be introduced only in Lok Sabha. We know very well Lok Sabha has an upper hand in terms of money bill. Ordinary bill can be introduced in both the houses, and both the houses have equal power in terms of ordinary bill. But when it comes to the money bill, Lok Sabha has the upper hand compared to the Rajya Sabha. But when it comes to amendment bill, both the houses have, equal power. There is no difference. Anyone can introduce. The other person can, the other house can, give their accent. All these things are there. But when it comes to constitutional amendment bill, the state legislature cannot introduce the bill. So here the president is not in the picture at all, since they are not, they are not having the power to introduce a constitutional amendment bill. Yes. Next comes the repeal of farm laws. What is this repeal of farm laws? We know very well that three farm laws have been passed, and there was a, agitation regarding these farm laws. There was, the farmers, especially in Punjab, Haryana area, for almost 1 year they have been, protesting against these farm laws. So we'll see what are those farm laws. They have been repealed. Why they have been repealed? All these things we'll be seeing. Fine. So the share of GDP from agriculture and allied sector to the total economy is almost 20.2 percentage. Fine. The small and marginal holdings constitute about 90 percentage of total agricultural land holdings. Fine. So the top 10 percentage of households are cultivating almost 50 percentage of India's total cultivable land. These are all the, data which you can be using in terms of agriculture related topics. Almost 2/3 of Indian agriculture is rain fed. Okay, who depend on rain. So the income levels of farmers on an average have come down to roughly rupees 9,000 per month according to various government reports. See, average it is just 9,000 per month. Fine. So we know that almost 20.2 percentage of the output is from the agriculture and allied sector. But what is the income level of farmers? It is only rupees 9,000 per month. So what are all the farm laws that have been repealed? We'll see that. The Farm Produce Trade and Commerce Promotion and Facilitation Act of 2020. So what is this act? The Farmers Produce Trade and Commerce Promotion Facilitation Act. So what is this talking about? From the act name itself, you know that it is about, trading of the produces. So this aimed at allowing trade in agricultural produce outside the agricultural produce market committee mandis. Okay, this without, coming to the mandis, the products can be sold outside also. So that is what is this act. So it provides for the creation of an ecosystem where the farmers and traders have the choice relating to sale and purchase of farmers produce. The mandi will not say anything. They are bypassing the mandis. This facilitates remunerative prices through competitive alternate trading channels. So it promotes efficient, transparent and barrier-free interstate, intrastate trade and commerce of farmers' produce. The produce will have a reach outside the physical premises of market or deemed markets notified under various state agricultural produce market legislations. So this also helps in electronic trading. Okay. So it will help the farmers of the region with surplus produce to get better prices and consumers of regions with shortages and lower prices. Fine. Next, so next law is the Farmers Empowerment and Protection Agreement of Price Assurance and Farm Services Act of 2020. So here it will give a framework for contract farming. So this particular Farmers Empowerment and Protection Agreement of Price Assurance and Farm Services Act of 2020. So here it provides a framework for contract farming, and it will protect and empower farmers to engage with agribusiness firms. Processors, wholesalers and exporters are large retailers. So what happens? They can take up farm services and sale of future farming produce at a mutually agreed remunerative price framework, so that the farmers can use, modern technology, better inputs, and cost of marketing will get reduced and improve the income of farmers. So they will engage directly in marketing. So what happened? The intermediaries will be, removed, and the proper price, what is the output, will be given to the farmers. Next is Essential Commodities Act of 2020. So what is this Essential Commodities Act? So this is an amendment act. Okay, so what happened in this amendment act? They removed commodities like cereals, pulses, oil seeds, edible oils, onion and potatoes from the list of essential commodities. This will remove fears of private investors of excessive regulatory interference and their business operations. Fine. So essential commodities, if they are included in essential commodities, there are certain rules and regulations, like how much you can hold as a stock, how long you can, all these things were there. But now since it has been removed, the private investors will have a free hand in handling these producers. The freedom to produce, hold, move and distribute and supply will lead to harnessing of economies of scale, attract private sector, foreign direct investment into agricultural sector. Fine. So what is the need? Why these three laws was introduced? So first is agricultural marketing. So there was restriction for farmers in selling agricultural produce outside the APMC market yards. But now since these farm laws have come, they have a free hand. They can sell it to a competitive pricing. That there is a farmer, so he is having a produce. There are two buyers. He can choose a competitive price and he can give them. So the barriers existed in free flow of agricultural produce between various states. Owing to the prevalence of mandis, legislations enacted by the state governments also has been removed. But what is the high risk here? Indian agriculture is characterized by fragmentation. We know that very well. What is the problem in terms of fragmentation is that, so when lands are fragmented, the inputs that are given are not cost effective. For smaller lands, when you give inputs, it can be like irrigation process, usage of technologies, everything will become more costly. It will reduce the cost effectiveness. So that is one problem here. We have the fragmentation and weather dependence. I told you about, we saw here that about two-thirds of Indian agriculture farmlands are rain fed. That is, they depend upon the weather condition, which is a riskier form. Fine. So, next is the agriculture is risky, inefficient in respect of both input and output management. Price instability was there because of a because of a problem in terms of supply and demand. There was a high instability. So when there is an instability in this, the price was also very unstable in nature. So what happened? The farmers suffered huge losses when there are bumper harvest. For example, tomato will become very cheap when there is a bumper harvest because everyone is having tomato harvest. So the supply is very high, the demand is less, so the price will fall down. And that too, when it is a perishable good, you cannot hold it, you cannot stock it for very long time also. So what happened? The farmers suffered a very huge loss since they don't want to waste, since it's a perishable good, they start giving it for a very less price. Fine. So there was a need to create a competitive market environment to prevent the wastage of agri-produce and due to the lack of storage facilities. Okay, so whatever we saw now had a very good. We just saw what are all the three laws, why it was produced. So whatever we saw now looked like it is like very useful for the farmers. All these things, but why there was a very big opposition, even though they have all these good things on their side. First is APMC mandi. So what happened? The farmers feared that this mandis where they sell their produce would be shut down once private players started trading in agri produce outside the mandi premises. So what happens when the private players start playing in these? Sometimes they can start controlling the price. So the farmers are in risk of losing the minimum income also. Next, so MSP demand. Minimum support price matters more in the state of Punjab and Haryana, where the government purchase over 80% of wheat and rice output for this National Food Security Act supply. Fine. So that is why I told you already for almost 1 year, the farmers from Punjab and Haryana have been, opposing this law. So there has been fear that once this mandi system become redundant, the procurement base of MSP too would come to an end, leading to the demands of legal backup for MSP. Fine. Next. The government fixes MSP minimum support price at 1.5 times the cost of production using the formula, A2 formula for calculating the cost of production. But farmers are demanding the government to rely on the formula recommended by the National Commission of Farmers. Next is cooperative federalism. Agriculture and markets are state subject. So there was once a question too that farm agriculture and markets are state subject. But how the parliament has made these formulas? Fine. So the farm legislations are seen as a direct encroachment upon the functions of states against the spirit of cooperative federalism. What is cooperative federalism? Is cooperation between union and states. So these terms like cooperative federalism, competitive federalism are all very important. Instead of just writing, cooperation between the union and state, harmony function of union and state, just write cooperative federalism. The center, however, argued that the trade and commerce in the food items is a part of concurrent list. Fine. So the states are agitated because farming and market are in the state list. But the union has argued that trade and commerce is in the concurrent list, and these laws are depending upon the trade and commerce. So the parliament has the power authority to create law. That is what is the argument of the center. So there is no mechanism for price fixation. The Price Assurance Act does not prescribe the mechanism of price fixation. So it gives a free hand to the private corporate houses that can lead to farmer exploitation. They might ask for a very low price. Since the government is assuring that this is a minimum price, but when this Assurance Act is not prescribing the mechanism for the price fixation, what might happen is the private player, I told you already, all these three formulas when you're having a look at, you will understand that these three formulas, though it might look like the farmers have a very good outcomes from them, it is leading to foreign direct investment, private investors, and then the farmers can come outside and have a direct contact with the buyers. Middlemen will not be there. All these things are there. But on on a big picture, if you see, the private players will have a free hand, and that they might start controlling the farmers because they have the free hand in fixing the price here. So the farmers are forced to give the producers in the prices what the private players say. So there is a lack of resource for legal battle with private corporate entities. Nowadays there are so many movies, which speak about what corporate entities do, right? So when you're comparing a farmer and corporate entity in a legal battle, you know very well who might win. Food security. Easing of regulation of food commodities in the essential commodities list would lead to hoarding of farm produce. That's what I told you. See, cereals, pulses, oil seeds, onions, potatoes. Onions and potatoes are staple food in many of parts of a country. So when these are removed from essential commodities list, what happens? The players, whoever it can be, the people in the market can hold stock. So what happens? When there is a high supply, they'll hold stock. Okay, they'll hold a very big stock. Later, what happens when the supply is very less? They will start selling it for a very high price. So what happens is that the basic staple foods, onions, potatoes, cereals, pulses, will be of a very high price that poor cannot afford. So this will in turn disturb the food security. So easing of regulation of food commodities from the essential list will lead to hoarding of farm produce during the harvest season when the prices are generally lower. For example, now pulses, you take some pulse. I'll take, moong dal. Moong dal. So what happens now? Moong dal is rupees 10 per kg. So I'm having a shop. So what I'm doing, I'm holding hundreds of kgs. So now it is 10 rupees per kg. So I'm holding it now. Later on, what happens when the supply is very less, the harvest is very less. So these are like you can store. The shelf life is good when you are storing it in a proper manner. So what happened later on? I'm selling it for 50 rupees per kg. So 10 rupees per kg is an affordable price. 50 rupees per kg is not that affordable price. So what happens? This is becoming, even though it's an essential commodity, it is becoming very costlier for everyone to afford. So that will be a problem when these things are removed from the essential commodities list. Methods of implementation. So government initially cleared them as an ordinances with the haste that ignited the protest. The communication to people in general, farmers especially, added the issue. So what happened is it created a fear among the people because the government did it in a very hasty manner. They did not, have have any program to. They did not even try to explain the people about these laws. The demand for scrutiny of bills by the parliamentary panel was dismissed, and the government rushed the passage of legislation. So, what were the consequences of passage of farm laws? What happened? We know very well. Sporadic protest against the farm laws later expanded to the nationwide blockade where farmers and unions call it as Delhi Chalo movement. The protests that began in Punjab moved to outskirts of national capital and involved farmers Punjab, Haryana, Rajasthan, Western Uttar Pradesh and Madhya Pradesh. 11 rounds of talks were held between the government and representatives of farmers between October 14, 2020 to January 22, 2021, but had no result. On January 12, 2021, the Supreme Court stayed the implementation of three laws. Since the stay, the laws have been suspended by the government. So what features have got lost in the outcry of protest? Elimination of cartelization. The act aimed, so what happened is, we saw what is the law. So what are the positive of that law? What are the negatives of that law? What happened after the agitation began? Okay, but what we missed in this law? Okay, so we have agitated and the law has been removed. But what are the negative outcomes of removing this law? An elimination of cartelization. So here it tried to prevent the pressure under which the farmers were put by the trade cartels. Next is middleman issue. We saw this, the farmers can directly contact the buyers. In most of the cases, the middleman is the one who is, profited the most. For example, I'm producing tomato and the farmer is giving it for 10 rupees per kg. But in the market, we get it for 50 rupees per kg. Why? Middlemen will be there who have their own profits. So if we are avoiding this middleman, we can get this straight at 10 rupees per kg, but because of this middleman, we are getting it 50 rupees per kg. So here 40 rupees per kg is going to middleman. So that problem was about to be removed, but it's product quality. The quality of produce has been a point of dispute between the traders and farmers, and the act ensured farmers to take their produce to any part of the country or sell to anyone with whom they were comfortable in such case of dispute. Next, contract farming. The Price Assurance Act enabled contract farming where the buyer couldn't have backed off after entering into an agreement, but its impact was lost in the political outcry. So next is distress sale. What happens in contract farming is, so there is a contract. A company is making contract with list of farmers. The farmers relying on the contract has produced. Now the company is saying, no, I'm not satisfied with your product, I'm backing off. But this Price Assurance Act was giving an assurance to the farmers that the one who has created the contract cannot back off. And that was lost. Distress sale. The objective of Essential Commodities Act amendment was ensured that the farmers didn't have to resort to distress sale. Okay. What does the repeal indicate? The repeal indicates that any future attempts to reform the rural agriculture economy would require a much wider consultation, not only for better design of reforms but for wider acceptance. So it's not like with hasty passage of any laws will not be accepted by people. So it has to be properly consulted. What the agrarian needs is a new deal and assurance that farmers' interests would not be hitched to immediate compulsion of interest groups, be it political or corporate. Okay, so farmers have proved that you know they cannot just agree to anything for interest of particular group. It can be a political group or corporate group. Next is 10.5% special reservation for Vanya Kula Kshatriyas. What is this? So what is it? The Madras High Court has recently squashed the 10.5% special reservation for this Vanya Kula Kshatriyas within the overall 20% quota for MBC and DNC. DNC is denotified communities. So this has again highlighted the importance of quantifiable data as prerequisite for reservation in education and employment. See, we saw about this EWS. There the Supreme Court has questioned the government. How did you come to a conclusion that 8 lakhs will be a proper criteria? So what is the data? On what basis you have decided this? The same way the Madras High Court also has squashed this 10.5 percentage. On what basis? They have questioned. So in 2021, the Assembly passed a special act which divided the most backward classes or denotified community category into three parts. What are those? So of those, so they are dividing it in three parts. Of those, 10.5 percentage of share was given to, that is a larger share was given to Vanyakula Kshatriya and its various subcats. So the subdivision was to have 7 percentage for DNCs and a section of MBC, while remaining 2.5 percentage was meant for the rest MBCs. Okay. It was justified based on the report that second backward class commission, which stated that 1 year population was 13.01 percentage of the then population in 1983. So what happened? There is a special act passed in 2021 in the assembly stating that most backward class and denotified communities, they are dividing it into three parts. So in that three parts, 10.5 percentage is given to Vanyakula Kshatriya and 7 percentage is given to two DNCs, denotified communities, and only 2.5 percentage was given to the rest of MBCs. So the government is justifying it, saying that the second backward class commission is stating that 1 year population was 13.01 percentage of the then population in 1983. So is it possible for the states to make changes in the backward classes? What is the power of the state? According to the 102nd Amendment of the Constitution, which created the National Backward Class Commission, and this empowered the President to notify the backward classes list for each state. The Supreme Court ruled that in the Maratha reservation case, the amendment took the power of the state to notify or identify OBC. So, since the President is having the power to notify the backward classes, the state does not have any power to notify who are all the backward classes. But later in the 105th Amendment, it made it explicit that the states could make changes in their list. So this is the time. So 102nd Constitution Amendment is creating National Backward Class Commission. So under this, the President is having the power to notify who are all the backward classes. So the Supreme Court ruled, according to this amendment, the Supreme Court is ruling that according to the Maratha reservation case, the state does not have any power to notify or identify the OBCs. Later in the 105th Amendment, it is explicitly mentioned that the state can make changes in their list. But still, Even though the state has power, why the High Court has quashed this? The legislation was challenged before the High Court, which held it unconstitutional because there is a lack of adequate quantifiable data. Why this 10.5 percentage has been given? The government did not wait for the report of a commission it had appointed earlier to gather quantifiable data to justify the state's 69 percentage of total reservation. So the other ground was the separate reservation of one caste amounted to discrimination against all other castes. We just saw 10 percentage, almost 10.2 percentage is given to one particular caste, where the other MBCs are having only 2.5 percentage. So the ground was that the separate reservation of one caste amounted to the discrimination. Even the BC Commission report 2011, which justified the 69 percentage reservation for BC, MBCs or DNCs and SC/ST under the 1994 Act, did not give any community-wise breakup of representation in the government services. So it was like accepted. So what was the stand of the State Backward Commission regarding the internal reservation? The first commission was constituted in 1969, headed by A.N. Sathanandan. So it spoke about having a device for removing the top layers of communities, which we call it as creamy layer concept. Next, the second BC commission, headed by Amba Sankar, advocated compartmental reservation by grouping the BCs on the basis of backwardness. That's why we have BC, MBC, most backward classes, denotified communities, etc. So within backward classes, you have separation based on the backwardness, based on the degree of backwardness, amount of backwardness. The concept of quota within quota is already in place in Tamil Nadu. How? In 1989, a new category called MBC DNC was carved out of BCs and given 20% exclusively from then quantum of 50 percentage. In 2007, Muslims in the BCM, they called as backward community Muslim BCM, were provided 3.5 percentage reservation. In 2009, 3 percentage reservation was provided for Arundhatiars out of 18 percentage of quota for SC. So you have a broad division. You have a broad division called as general, BC, SC, and ST. So within this, you have a division called as BC, MBC, DNC. In SC, you have a 3 percentage specially reserved for Arundhatiars alone out of 18 percentage. So this is a 69 percentage rule of reservation. Okay. So open competition, that is general category 31 percentage, backward class 26.5 percentage, backward class Muslim is having 3.5 percentage, MBC and DNCs have 20 percentage. In scheduled caste of 18 percentage, they are dividing it as generally scheduled and Arundhatiar, which is 3%, Arundhatiars 15 percentage, 3 percentage, and total you have it as 18 percentage. And scheduled tribes you have 1 percentage. Right? So what are the effects of the verdict? The state government is planning to appeal to the Supreme Court. So any change in the state's 1994 Act would require an amendment to the law as well as president assent, which may complicate the existing internal quotas given to Muslims and Arundhatiars also. Okay. So already we have this 3 percentage for Arundhatiars and 3.5 percentage for Muslims. So this will also have a question. So the High Court has mentioned that these two quotas were backed by census data and valid recommendation. So this will not have any issue. But now the present 10.5 percentage of this Vanyakula Kshatriyas are questioned because they don't have a proper data. So as always, I'm revising what are all the topics we saw today, what all we have discussed today. We saw about parliamentary committees. So what are all the parliamentary committees we saw? And what is the difference between parliamentary committee and consultative committee is what we discussed. And then we discussed about POXO, prevention of children from sexual offences. And we saw some definitions, what is the act about all these things. And then we saw about ordinance promulgation in India. we saw two datas. What is the ordinance promulgation power of president, and we saw what is the ordinance promulgation power of governor and their respective articles from the constitution. Then we went to Panchayat's extension to Schedule Area Act of 1996. So we just discussed about what is that, what is the power of Gram Sabha in this, and then we saw about state bills and president's veto power with respect to it. We discussed in detail about farm law. What is the status of agriculture in our country? What are these three formulas? The Farmers Produce, Trade and Commerce Promotion Facilitation Act of 2020, the Farmers Empowerment and Protection Agreement of Price Assurance and Farmers Service Act of 2020. So this Farmers Produce, Trade and Commerce Promotion Facilitation Act is giving a free hand for the farmers to sell their produce anywhere in the country by bypassing the mandis. Next is about the Farmers Empowerment and Protection Agreement of Price Assurance and Farm Service Act is concentrating on contract farming. It was giving a proper framework for contract farming. Next, the Essential Commodities Act of 2020. So here removed, it is an amendment act which we had, the act we had already, it is amended in 2020. So it is removing some important producers like cereals, pulses, oil seeds, edible oils, onions and potatoes from the essential commodities. So what happens is that it is removing some regulations which can open opportunities for different players to um, distribute the supply in a effective manner. What is the need for implementation? We saw some issues like problems in agricultural marketing, and there is a risk for the farmers because two-thirds of the farmlands are depend upon the rain. So the weather condition can create a risk in terms of farm producers. There is a high price instability. So what is the reason for opposition is that the farmers were agitated, farmers started worrying, what if these are shut down? There will not even be a minimum assurance for the producers. And even the government also hastily passed the law which created even more suspicion in the people. So cooperative federalism was also disturbed here because since farming and marketing, agriculture and marketing is in the state list, but the union government gave its own explanation saying that trade and commerce is in the concurrent list. So what happened after that? The farmers protested. Almost 11 rounds of talk took place. Then finally, the Supreme Court issued stay on these three laws. So the government had to suspend these laws. So what are the problem? So even though this law had their own negative part, they also had some positive part on the other side, like elimination of cartelization, solving the middleman issue, product quality related issue, which we missed from these laws. Next is 10%. Next we spoke about reservation. Yesterday also we spoke about reservation, that is economically weaker section. Here in this also 10.5 percentage of special reservation of Vanyankula Kshatriyas was squashed by the High Court. On what basis? On the basis that there is inadequate quantifiable data. Okay, so what will be the problems here is that we spoke about reservation within reservation. Those examples are nothing but in BC community Muslims have a special reservation, and in scheduled caste Arundhathiyar have a special reservation within reservation. When this 10.5 special reservation for Vanyankula Kshatriya is questioned, that also might be at stake. But the High Court said that those two reservations have proper quantifiable data, but this 10.5 percentage is not having proper quantifiable data. That is why it is held unconstitutional. So thank you so much. We'll meet in the next class on Monday.